Please get ready for a dictation of exercise 12 and 13 from January 2019 issue of Progressive magazine. 5 seconds. Start. Sir, it is therefore fully in order that the company should be asked to supply only such information as may be prescribed by the government to a shareholder in the first instance, and only those shareholders who really require the entire information in the annual report should be provided with it, as the proposals in the amendment bill and the further amendments suggested will show that this full information can be obtained by any shareholders on demand free of cost. It cannot therefore be said that the interests of the shareholders are not being adequately safeguarded. So far, the small depositors whose deposits were not being refunded by the company in time had no remedy under the Companies Act. He had to go to the civil court to enforce his claim. We have provided in this bill that a depositor whose money is not refunded in time can approach the Company Law Board, which, after looking into the aspects of the matter, can direct a company to repay the deposit on certain conditions, and if the company defaults in obeying this order of the Company Law Board, it is able to be punished. I am sure all the members would agree that this is a major step towards the protection of the interest of the depositors, particularly the small ones. It will be seen that in various existing provisions of the Companies Act, there are specific limits prescribed, such as the ones for disclosure of salaries above a certain amount, compulsory appointment of managing director, etc. With the passage of time, many of the limits become outdated and need to be changed. It is felt that flexibility in these matters would be of great benefit, and with this aim, it has been provided that these provisions be changed to such limits as may be prescribed by the government. My friend has mentioned that instead of the present provision that a managing director or a whole-time director be appointed in a company with a paid-up capital of rupees 25 lakhs, that limit should be raised to rupees 5 crores. The provision that we have proposed in the bill and the amendments that have been moved will take care of this problem. Whether the limit should be raised to rupees 5 crores can be determined from time to time, taking into account all the circumstances. Some of the provisions relate to the removal of the lacuna are observed, and it is seen that undue advantage is being taken by the company to avoid the intention of the law. Such a lacuna must be removed for the benefit of the shareholders now. Mr. Vice Chairman, I rise not only to oppose the bill that has been brought before this House today, but to express the hollowness of the objects and reasons which the Minister has just placed before the House. I come to the point, and I will have to give a little background because this is the first legislation of its kind in this country, which was brought forward in 1969. Former Prime Minister, while dissolving the Lok Sabha in December 1970 and calling for mid-term elections, addressed the nation on the radio, and one of the achievements she claimed was that the government had set up the Monopolies and Restrictive Trade Practices Commission to control concentration of economic power, which had got concentrated in a few hands, and to go forward on the road to democratic socialism. After its enactment, this act has already been amended a number of times. In November 1980, this was the first amendment when they said that export production should be excluded from the purview of the total production taken because that does not affect the consumer as it goes out of the country. Stop.